Good morning, Carlos.
Good morning.
It's so nice to see you, and I want to thank you for giving us some of your time this morning. I know you've been a longtime member of CPR's panel, and it's my pleasure to sort of help introduce you to the rest of our community. I've looked at your resume, and you have such a wealth of experience, and you've worked as counsel in such a wide variety of dispute contexts, from construction to non-competes, banking, civil rights, intellectual property. Can you talk a little bit about how that broad range of experience as counsel helps equip you for the arbitrations that you now do?
Yes, I'll be glad to. My background has been quite varied. It has taken a long path, and through that path, I have been exposed to an evolving exposure of different fields of law. And for example, I started with Baker McKenzie in 1978. I was at that time concentrated as a tax attorney. I did nothing but eat, live, and sleep tax law literally 7 days a week. I did work 7 days a week back then. I no longer do that. And then around 1982, I then joined Coopers and Lybrand as their international tax manager in Miami and continue focused on my tax practice in the Central and South America region. And then later on, I migrated with Gaston Snow and Eli Bartlett, which back then was the second or third oldest law firm. I don't remember, it was the second or the third oldest law firm in the US. And I was located in Miami, and I worked on tax projects with the Boston, New York, and the Palo Alto office. And that was my exposure with continued exposure to, again, tax fields, but then it started opening up into doing commercial and business deals, not just tax deals. And then I went on my own around 1989, and my partner and I, who's my partner today, we joined up in 1992. And from 1989 forward, the variety of projects that I worked on, domestic, international, incoming transaction, outgoing transactions, it was just exploded. And the variety of clients that I've handled over the years has been literally from A through Z. That variety and that exposure over so many years is what permitted me to handle so many different projects that I never would have been able to handle if I were with a very large firm and just pigeonholed into a specialty.
Great. And can you talk a little bit about your path from, functioning as counsel into your neutral work?
Sometime around 1995, I kept hearing a lot about arbitration. It was up and coming, and I wanted to learn more about it. I ended up joining American Arbitration Association as an arbitrator. And since then, I have been an arbitrator and participated in the following organizations: the AAA, the ICDR, CPR, ICC, a Chartered Institute of Arbitrators, AREAS, which is the arbitration organization for reinsurance disputes, and also handle a number of arbitrations where there are no rules and it's not administered by any organization. Overall, I've been exposed and have handled either a sole arbitrator or a three-member panel, at least somewhere between 150 and 200 cases. I don't know the exact number, but at least that number.
Having done this sort of large number over the years, can you talk a little bit about, what you enjoy about the role of the arbitrator?
I do. I find the role stimulating. I believe sincerely that arbitration is a path for efficient resolution if and only if the arbitrators are committed to make it happen. To do that, one needs to roll up one's sleeve, get your hands dirty, and work with counsel in a constructive and an interactive fashion to push it along and try to find ways to cut costs down. And by cost, I mean cutting down the time involved in resolving the case. And one quick example is to try to get the cases to trial in less than 1 year. As a sole arbitrator, I've been able to do that. On a three-member panel, I'm usually successful in doing that, especially if I'm chairperson but as a wing, it's not always as easy.
So you're really working to keep the process streamlined, focused, targeted,
And move
moving
along
forward.
and moving it along.
What are the common mistakes that you see counsel make in arbitration?
There are some. The most salient of all that I have experienced and witnessed over the years is that many counsel are just simply unprepared. How unprepared? They're unprepared on their depth of knowledge of the facts of their case and the facts of the other party, the opposing party. And it seems like almost invariably they wait until discovery comes around in order to develop the facts, sink their teeth into it. But so much more can be accomplished and done if they had been utterly and totally prepared from get-go. It makes the scheduling order easier, it makes the discovery process easier, and it helps them focus where do they want to be when they go to final trial. Two other ones, which I can also mention, the higher the level of cooperation between counsel, the easier it is to get things done. So cooperation is a very high order. Very little can be gained by not cooperating and working on something. That doesn't mean you cannot defend with to the utmost of your ability the position of your party. You can do that by being fully cooperative. You do not need to be, and do not confuse it with being uncooperative. And the final one is be truthful to the facts. And when you argue your positions, and oftentimes attorneys try to bend and twist the truth. It only comes back to bite them in the ankle.
Sounds like you might have had some experience coaching or guiding or maybe presenting some of these pearls of wisdom to advocates in the past. I'm wondering if you have a sort of distinguishing feature, distinguishing quality as an arbitrator, something that maybe makes you not special, qualities that maybe not every run-of-the-mill arbitrator has.
I think I do. I think I have some that you don't find with all arbitrators. One of my top objectives is to promote to the maximum level possible mutual agreement and cooperation between counsel. And to do that, I maximize the level of mutual agreement on everything that is done during the proceeding. That includes, and it starts with the scheduling order or the organizational meetings, depending how what terminology is used under different rules. But at the end of the day, it's the same thing. You're scheduling how the entire proceeding is going to look like from beginning to end through the final hearing. And in the scheduling order, I have successfully, as a chairperson or individual sole arbitrator, being able to get everything agreed upon by mutual agreement with counsel. I don't have to impose my will or my preference on anyone. And that is very important. Why? Because that maximizes it starts the process of cooperation. They have to work together to agree on things. And that's the beginning of the process. And if I can accomplish that, well, that's the first brick on the foundation to move along and to get people to talk to each other and to realize that we're going to do this together. We're going to all row in one direction. The other one that I try to do is minimize motions. I don't like long motions unless they're absolutely necessary. Indeed, we try to cut them down to just 2 or 3 pages. And I tell them that. And even try to cut them down even further with no motions. Like just send me an email. Tell me what the problem is in a few sentences, and let's set up a conference call quickly. And then it's easier to do when you're a sole arbitrator. And it also can be done even there is a panel, because even though you have a full panel, you can, again, going back to the concept of cooperation, persuade counsel. If you want this thing done sooner or faster, if you want this to cost less for your clients, only allow one arbitrator to handle everything from beginning until the final trial. and then he will make all the decisions. Now, to protect counsel from feeling like I never should have agreed to do that because I don't like his decisions, we have an escape clause. And that is, if either side disagrees with a decision made by the arbitrator, they have 3 days to ask for the en banc to review the decision. And that's their escape clause, to feel comfortable that they don't like what is happening. And there's an escape clause to run to the aid of all 3 arbitrators and say, we disagree with Mr. Romero. Can you please review this matter and see if you decided differently for the following reasons? And that's what I try to do: promote cooperation and push the progress as fast as possible, as cheap as possible.
So you've talked a little bit about the procedural efficiencies that you try and build into your process, but we've also talked in the past that substantively a very large percentage of the claims that are brought before you actually settle
Yes.
In the arbitral process. I think you said something like 95% when you're the sole arbitrator. And I'm wondering if you can talk a little bit about how you facilitate that.
Yes, I again, one needs to be focused, driven, and be in communication with the attorneys for the purpose of flushing out the facts, trying to understand and define the scope of the controversy. What is the disagreement? What are the boundaries of that disagreement? And what will it take to solve the disagreement? And I can come up with an example which will highlight that. A few years ago, on a 3-member panel, where the parties agreed to allow me to make the driving decision, but in this case, we did it with the full panel. And there was a long-distance phone service company that provided nationwide long-distance services to the public. And there was a service billing provider that handled all the billing, processed all the phone calls, and then divided up which carrier gets what piece of the fee, and what is the ultimate payment that would be made to the telephone long-distance provider. And the telephone company claimed that the software billing provider had a very mischievous source code, and that source code supposedly generated false billings or generated bloated, inflated billings. And then how can one get an independent expert? I mean, how can you get an expert representing the phone company to go in and audit a live system without interrupting the process? And how do you take that active billing system and upload data backups from prior years in order then to examine it without interrupting the business operations? It was challenging. And then it occurred to me, well, let me ask this question. So I asked the software billing company, I said, how confident are you that your source code is clean and there's nothing mischievous about it? Absolutely nothing mischievous about the source code. It is clean. Are you sure? Yes. Are you prepared to put the money in your mouth? He goes, yes. He goes, well, have a proposition and let's test it. It says, will you be willing, if I find an independent IT company that will set up, duplicate your computer system, your operating software, your billing software, and allow the other side to pick at random 1 or 2 backups to upload into this independent contained operating system and computer system to test it and kick the tires and to see if what you're saying is true or false? He goes, sure. He goes, okay. And I asked the other side, are you prepared to do that? Absolutely. They were dying to do it. And that's exactly what was done. The parties hired an independent company to come in and duplicate the entire computer operating software system and then uploaded the data. This way, everything was contained, confidential agreement provided to protect the data, and only the experts were allowed to look at the source code to protect the secrecy of it all. Well, after kicking the tires until they were blue in the face, it turns out that the source code was clean and nothing was found. Obviously, the case settled and never went to trial. That's an example.
So it sounds like you're always sort of thinking creatively of if there's a data conflict, how do we solve the data conflict? How do we get the parties on the same page? And that sort of creativity oftentimes leads for early case resolution in the process.
That's correct. And that takes a keen perception of the interaction between the parties as to what one party perceives the problem to be and what information or evidence they need in order to prove their case, and the other one, what information or evidence they need to end the case. And understanding what that evidence is, forcing the parties to divulge and identify those moving parts is what permits me to focus on it and say, I have an idea.
Great, great. Well, that's all we have for today. Is there anything else you'd like to share with our community about your work and role as an arbitrator?
I started arbitrations not knowing what was going to happen. And since 1995, now it's been 27 years. And I've grown to enjoy it. I've grown to be stimulated by it. And I make myself available to help the parties out, even under strained conditions, to make it happen.
That's great. Well, thank you so much for speaking with us, and
Thank you, Ellen.
look forward to future collaborations.
Thank you very much, Ellen.